Imagine a state's entire prison system just buckling under pressure. And this huge question lands right in the Supreme Court's lap. Does the Eighth Amendment get violated if prisoners aren't even getting basic necessities?
Yeah, it's a fundamental question, really.
We're talking about conditions so bad that a massive court decision involved, tens of thousands of prisoners. It really ignited one of the fiercest legal debates we've seen in a while.
It certainly did.
So today, we're diving deep into that legal storm.
That's right. We're looking at the landmark 2011 Supreme Court case, Brown v. Plata. And our mission for this deep dive is really to unpack the arguments, from both sides, the majority and the dissent.
Get into Justice Kennedy's and Justice Scalia's heads a bit.
Exactly. And understand the whole context of California's prisons, how they got into that state, and also wrestle with those bigger legal and philosophical questions about, well, what is the role of the courts?
It sounds like a case with layers upon layers.
Oh, absolutely. Justice Anthony Kennedy wrote the majority opinion, and Justice Antonin Scalia penned this very powerful dissent. It really gives us a fantastic window into how American law, especially through the courts, evolves.
Okay, let's unpack this then. The Eighth Amendment, it bans cruel and unusual punishments. That sounds straightforward, but what does it really mean? How did we get from worrying about, say, torture devices to looking at prison conditions?
Oh, well, the literal text is pretty short. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. That's it.
Seems clear enough.
Originally, yeah, the framers were definitely thinking about specific barbaric punishments common back then in Europe. Things like drawing and quartering, burning at the stake, horrific stuff.
Things nobody would defend today.
Exactly. And someone like Justice Scalia, who was a committed originalist, argued pretty forcefully that we should interpret the Constitution based on what those words meant then, back when it was written.
Stick to the 18th century definition, essentially.
That's the core of the originalist view, yes, not to stretch it beyond that original meaning.
But here's where it gets really interesting, isn't it? How did we make that leap? From literal physical torture to scrutinizing, the general state of a prison, the day-to-day life inside.
Yeah, that's the crucial evolution. It happened over time, but the Supreme Court really clarified things in the 1970s. There was a case, Hutto v. Finney, in 1978, which basically said the Eighth Amendment covers both specific inhumane punishments and the inhumane treatment of prisoners while they're locked up.
So it's not just the sentence itself, but how the sentence is carried out.
Precisely. This expanded interpretation meant the amendment prohibits, and this is a key phrase, penalties that transgress today's broad and idealistic concepts of dignity, civilized standards, humanity, and decency.
Today's broad and idealistic concepts. That sounds much more flexible than just banning drawing and quartering.
It is, and that shift is what made prison conditions themselves subject to Eighth Amendment review. It's the absolute bedrock for Justice Kennedy's majority argument in Brown v. Plata.
Okay, so the legal door was open to examine conditions. Now let's talk about California.
Yeah.
How did things get so bad there that this broader interpretation became so critical? Why did the Supreme Court even need to step in?
Right. It wasn't like a sudden collapse. It was more a perfect storm created by policy choices over decades. Two big ballot initiatives really set the stage.
Ballot initiatives. So things the voters approved.
Yes. First, back in 1978, there was Proposition 13. It drastically limited property tax increases and made it much harder to raise other taxes. Essentially, it put a tight lid on state revenue.
Okay, less money coming in.
Then, fast forward to 1994, and you get Proposition 184, the famous three strikes law, hugely popular. It mandated a 25-year sentence for basically any third felony conviction.
Wow, 25 years for a third felony, regardless of what it was.
Largely, yes. And the effect was predictable. The prison population just exploded.
So let me get this straight. On one side, you have policies demanding much longer sentences, packing the prisons.
Exactly. Very popular tough-on-crime measures.
And on the other side, you have policies making it really hard to raise the money needed to actually house and care for all those extra people.
You've got it. That's the core conflict. They built a system with one hand that the other hand couldn't pay for. The state just couldn't fund the massive increase in prisoners.
And that led directly to conditions deteriorating.
Directly. Things got so bad, the basic constitutional standards couldn't be met. And because these were both popular initiatives, the political system seemed kind of gridlocked, unable to fix it, which eventually is why the courts got involved.
And involved they got. So the Supreme Court majority, led by Justice Kennedy, They looked at all this and ultimately upheld the lower court's order, right?
Right.
What were the actual conditions that led them to take such a drastic step?
Oh, the conditions described in the court record are just staggering. California's prisons were designed for maybe just under 80,000 inmates.
So,
At the time the lower court ruled, they were holding around 156,000 people,
oh.
nearly 200% of capacity. And it had been like that for at least 11 years. This wasn't just, slightly crowded. It was systemic failure.
Can you give some specific examples? What did that look like on the ground?
Yeah, the record paints a grim picture.
Hmm.
Things like 200 prisoners crammed into a single gymnasium, maybe with only 2 or 3 officers watching them, or up to 54 prisoners having to share one toilet.
54 people for one toilet? That's unthinkable.
It's basic sanitation breakdown. It got so bad that in 2006, Governor Schwarzenegger himself declared a state of emergency. He cited, and this is a quote, increased substantial risk for transmission of infectious illness. And the suicide rate was approaching an average of 1 per week.
One suicide per week in the prison system.
Yeah.
That's horrifying. It sounds like the state itself acknowledged a crisis.
It did, and the medical and mental health care was just collapsing. They had about half the clinical space they actually needed. Sick inmates, sometimes 50 at a time, were held in what was described as a 12 by 20-foot cage for hours, just waiting to be seen.
Like animals.
The staffing shortages were critical, too. Over half, 54% of psychiatrist positions were vacant. One expert, Dr. Shansky, who used to run Illinois prisons, testified that even if they were fully staffed, they still couldn't meet the basic needs.
So even with more people, the system itself was broken.
Fundamentally, mentally ill prisoners faced horrific conditions described as telephone booth-sized cages without toilets. Wait times for mental health care could be up to a year.
A year for someone in crisis.
Yes. And tragically, one expert concluded that over 70% of the suicides were probably foreseeable and preventable. The conditions were just breeding grounds for disease, violence, unrest. It created this vicious cycle where they couldn't even implement fixes, like for suicide prevention, because there was nowhere safe to move inmates. Constant lockdowns further prevented care.
It sounds like a complete system meltdown. So given these just awful facts, how did Justice Kennedy connect this back to the Eighth Amendment?
Yeah.
How did he justify ordering California to actually reduce its prison population? It seems like a huge step for a court.
It was huge. Kennedy's reasoning really centered on human dignity. He argued that even though prisoners lose many rights, they don't lose their basic humanity. Since the state takes away their ability to care for themselves, the state must provide basic sustenance, and that includes medical care.
The state has a duty of care, essentially.
Exactly. And failing that duty, Kennedy wrote, may actually produce physical torture or a lingering death. He stressed that courts can't just look away. They must not shrink from their obligation to enforce the constitutional rights of all persons, including prisoners, even if that means getting involved in prison administration.
But what about the PLRA? That law Congress passed to limit court intervention in prisons. Didn't that tie the court's hands?
That was a major point of contention. Kennedy acknowledged the PLRA, the Prison Litigation Reform Act, but he argued that it actually authorized this kind of relief in extreme circumstances. The special 3-judge court found that overcrowding was the primary cause, the root cause of the constitutional violations.
So overcrowding wasn't just a problem, it was the problem driving everything else.
According to the lower court and the Supreme Court majority, yes. And they found that no other relief would fix it. They pointed to California's chronic budget problems and the lack of political will to build new prisons or properly fund the existing ones. So reducing the population was seen as the only viable remedy.
Okay, but the big question, the one everyone probably asks, what about public safety? Ordering the release or transfer of potentially tens of thousands of prisoners sounds risky.
Absolutely, and the court knew that. They explicitly stated they gave substantial weight to public safety concerns. They spent nearly 10 days of the trial just on that issue.
10 days just on safety.
Yes. Kennedy wrote that the population reduction could be achieved in a manner that preserves public safety. They relied on expert testimony suggesting that reducing overcrowding might actually improve public safety in the long run by allowing for better rehabilitation and addressing the root causes of crime.
How would that work? How could releasing people improve safety?
Well, the experts proposed several methods. Things like expanding good time credits for lower-risk inmates, diverting others to community programs like drug treatment or electronic monitoring, and handling technical parole violations like missing a meeting through community sanctions instead of sending people back to prison. The idea was that the state had options to make the reduction targeted and safe.
So the majority felt it was necessary, constitutional, and could be done safely. But then you have Justice Scalia on the other side. His dissent was, let's say, quite strong.
Fiery is a good word for it. He called the order perhaps the most radical injunction issued by a court in our nation's history. You can really feel the strength of his objection.
What was his main problem with it?
Fundamentally, he saw ordering the release of potentially 46,000 convicted criminals as completely unwarranted and unprecedented. He called it a judicial travesty. He believed it trampled on limits placed on federal judges by both statutes like the PLRA and the Constitution itself.
How did he read the PLRA differently from Kennedy?
Scalia took a much stricter view. He emphasized the part of the PLRA saying relief must be narrowly drawn and go no further than necessary to correct the violation of the federal right of a particular plaintiff or plaintiffs.
The particular plaintiff part. So he focused on individual harm, not the system.
Exactly. He strongly rejected the whole idea that just because the system was inadequate, every single prisoner's Eighth Amendment rights were violated. He thought the Eighth Amendment protected individuals from specific indecent treatment, not from just being in a badly run system.
So if prisoner A wasn't personally denied care today, their rights weren't violated, even if the system overall was failing.
That was his argument. He called the notion that every single prisoner suffered a violation simply by being in that system preposterous. And he pointed out, quite sharply, that the 46,000 people who might be released wouldn't necessarily be the specific prisoners who were part of the original lawsuits about medical and mental health care.
So the remedy didn't directly match the specific victims, in his view.
Correct. He saw a disconnect there.
Did he have broader concerns beyond just the PLRA interpretation about the court's role?
Oh, absolutely. He was deeply skeptical of what academics call structural injunctions. These broad court orders designed to reform entire institutions like prisons or school systems.
Why was he against those?
Scalia argued that traditional injunctions involved ordering someone to do, or stop doing, a specific, simple act. But these structural injunctions, he said, turn judges into long-term administrators of complex social institutions, making them act like governors or wardens, not judges.
Blurring the lines between branches of government.
Precisely. He also heavily criticized what he called fact-finding as policymaking. He argued that these kinds of cases force judges to make huge predictions about complex social issues, predictions based more on policy preferences than hard facts.
Like deciding the correct prison capacity percentage.
Exactly like that. He basically said, judges are lawyers, they're trained in law, they are utterly unqualified to make these kinds of large-scale empirical judgments about prison management or public safety risks. He felt these weren't really factual findings, but policy judgments dressed up as facts.
And that belongs to
The legislative and executive branches, in his view. Running prisons requires expertise, planning, money, things courts don't have. He saw this order as a massive intrusion on California's right to govern itself, a serious breach of separation of powers and state sovereignty.
Wow. So you have these two towering figures on the court, Kennedy and Scalia, looking at the same horrific facts, the same Constitution, the same federal law, and coming to completely opposite conclusions about what needed to be done and what the court was allowed to do.
It's a stark contrast, isn't it? And it really gets to the heart of some fundamental debates in American law.
It seems like this case is way bigger than just California prisons. It touches on how we even read the Constitution.
Absolutely. You see that clash between Scalia's originalism stick to the 1791 meaning and Kennedy's view, which embraces the idea of evolving standards of decency, allowing the Constitution's principles to apply to modern realities.
Like recognizing that systemic neglect can be a form of cruelty, even if it's not intentional torture.
Right. And it also forces us to confront that tension between judicial activism and judicial restraint. When should courts step in because rights are being violated and politicians aren't acting, versus when should they hold back, respecting the roles of other branches?
Kennedy seeing it as a duty, Scalia seeing it as overreach.
Exactly. And it even shows the push and pull between Congress and the courts. The PLRA was Congress trying to rein in judges in prison cases. Brown v. Plata shows the judiciary interpreting that law and, in the majority's view, still finding room to act decisively.
It reminds me of that analogy the lower court judge used. Something about a spider web.
Yes, the Plata district judge compared the whole situation to a spider web. You pull one strand, like overcrowding, and the whole web trembles. It highlights how these complex social problems rarely have neat, simple fixes. Everything is interconnected.
So as we wrap this up, it feels like Brown v. Plata leaves us grappling with this really difficult balancing act.
It really does. How do you uphold constitutional rights, especially for a population most people don't think much about, while also ensuring public safety and respecting the lines between courts, legislatures, and governors?
And it's striking that both Kennedy and Scalia said they were worried about releasing prisoners. They shared that concern.
Yes, both expressed grave concern. That's the phrase they used. But they completely disagreed on whether ordering releases was a necessary, legal, or appropriate solution.
So the case has implications that ripple far beyond California, right? For prison reform efforts everywhere, for how we think about constitutional rights.
Definitely. It continues to fuel the debate about the judiciary's role in tackling complex social issues, especially when other branches seem unable or unwilling to act. It's a landmark case for a reason.
It really challenges us, I think, to ask, what is the real cost of cruel and unusual punishment when it looks like systemic neglect? How does a society square its need for punishment with its commitment to basic human dignity, even for those behind bars?
Those are the hard questions, aren't they? It forces us to think critically about the incredibly tough choices governments and courts face when these fundamental values, safety, rights, justice, seem to clash. There are rarely easy answers.
Well, this has been a fascinating deep dive. Thanks for walking us through such a complex and important case.
My pleasure. It's a case that really makes you think.